Hello, and welcome to Canadian Lawyer TV. I am Tim Wilbur, Editor-in-Chief. Today, we're examining COVID vaccinations and the impacts of the pandemic on the workplace in Quebec. First, I'll introduce our panelists. André Sasseville and Annie Bourgeois are labor and employment lawyers and partners in Montreal at Langlois Lawyers. Nelly Admo is the head of the Human Resources Department at the Commission scolaire Marguerite-Bourgeois, the second largest school board in Quebec. And finally, Wendy Glaser is the manager of Human Resources Consulting at Solertia in Toronto. Since March 2020, Quebec's government has enacted several measures to tackle the spread of COVID-19. These measures include requirements for remote work where possible, the temporary closure of non-essential businesses, and the temporary closure of indoor dining. These measures caused several headaches for employers. Those who remained open during the pandemic have also had to comply with several health and safety measures. These measures have evolved and changed as the pandemic has progressed. Fortunately, efficient and accurate screening tests have been available in Quebec for some time. Reliable testing has allowed the government to enact several measures to reduce the spread. The government has also imposed travel restrictions within and outside of Canada, including quarantine obligations. Since the beginning of 2021, vaccines against the COVID virus have now been available. While vaccine supplies are limited, the Quebec government has established a vaccination priority list. The vaccination campaign for the general public is now well underway in the province. I'm now going to hand it over to the panel and invite Wendy Glaser to ask the first question.
Thanks so much for having me today. Since the beginning of the pandemic, many of our clients have had to temporarily lay off employees, impose salary cuts, or reduce employees' work week. What types of claims are they exposing themselves to?
So thank you so much, Wendy. That's a really great question that you just mentioned, because obviously the pandemic did have quite a lot of impact on various organizations and companies. And temporary layoff is definitely something that many employers had to do. What's important to know is that in Quebec, you can have an employee be on temporary layoff for a period of 6 months without having to pay any salary. But if the temporary layoff extends longer than that 6 month period, then there's an obligation to pay the minimum notice, which is established in the Act respecting the labor standards. So if those sums aren't paid, then there's a claim possible by potential employees. The question relating to salary cuts or hours that are being reduced, I know a lot of clients were inclined to do that because they were, in the mindset of saying, well, maybe we can still offer our employees a bit of work, even if it's not as much, instead of just nothing and terminating their employment. Obviously, in certain cases, if you have a salary cut that's higher than 10-15%, and if you're reducing someone's hours significantly, then the risk for the employer is that the employee will claim that it's a constructive dismissal because it's a significant change to the employment conditions. So that again can give rise to claims before the labor tribunals and the civil courts in certain circumstances. And the third thing, or the third situation that we saw quite a bit during the pandemic is job abolishment. So, a lot of clients just couldn't, justify or have on the payroll as many employees. So a lot of people were terminated for job abolishment. And again, that brings a number of requirements and obligations from the employer to pay a certain amount of notice. So in these three situations, whether it be, a temporary layoff that goes beyond 6 months, significant changes to the employment conditions, which can constitute a constructive dismissal, or plain out termination for economic reasons, in all these three situations, an employee can claim the reasonable notice as per the Act respecting the labor standards. The notice of termination, if you want, is between 1 and 8 weeks, depending on the number of years of service that an employee has. What's interesting with the pandemic is that there's an exception in the Act, which stipulates that in cases of an act of God, the employer does not have to pay the minimum notice period. So the question now becomes, can the COVID-19 pandemic be considered an act of God and exempt the employer from providing the minimum notice period? So for something to be considered an act of God, there's three criteria. It has to be external, so it's something that's out of control. It has to be unpredictable, and we're seeing more and more, health crisis around the world. So in terms of whether or not, a pandemic can be considered unpredictable, is getting a bit harder with time, but there are particularities to the COVID-19 crisis that could be alleged by an employer to say, look, this is really something that's out of the ordinary. The third criteria is that it's irresistible. So you can't execute the obligation, as per the contract. So here it's impossible to execute the work. So where the COVID-19 pandemic, I guess, may differentiate from other types of health crises is the fact that it's the governmental measures that were imposed. And the SNES, which is the organization that kind of covers everything that, deals with the Act respecting the labor standards, established that giving the governmental measures that were put into place, that could be an argument to put forward that it was an act of God. As we stand now, there's no cases yet, so it remains to be determined. It is, a high threshold to fulfill, but we're pretty sure that a lot of employers will try to make that claim, and it'll be interesting to see how the tribunals will decide on that note.
As you may know, I work in the second largest school board in Quebec, and the importance of our staff members and teachers to comply with the health and safety measures in place are obviously of the utmost importance. One of the obligations is to wear a mask. Since the vaccination campaign is well underway, what is the current requirement for mask wearing, and what should employers keep in mind regarding the medical mask?
So the principle is quite easy. The principle was ordered by the Labor Standards Health and Safety Commission. It was ordered as of April 8th, 2021. And there's an obligation to wear a medical mask certified by the Bureau de Normalisation du Québec at all times in the workplace in Quebec. But there are different obligations on that in cases when the employees work outdoors. So in the regulation of the Labor Standards Commission, an exception is made for employees working outdoors as long as their interaction are for less than 2 meters with co-workers. In such a case, it is not necessary for the employee to wear a mask. So this applies very widely in the construction industry and in other fields. For your school boards, for example, the employees working on the outside of the schools and etc. may require this exception to apply. Now, as for indoor workers, there were many consultations made to us right after April the 8th about the exceptions. So the three exceptions in the decree are: first, if it prevents the performance of a job-related duties. So this is not very complicated. If someone needs to have his head free, for example, if his phone will only open when he shows his face to his phone, it's obviously an exception. Same for the second exception. If it interferes with communication, understanding, or learning, it's been obvious that for teachers, that when they are in class and perform teaching, that the mask will not be required at all times, because they need to be free to express their point of view. Now, the third exception is the one for which there were many queries. The decree itself only says for health reasons. So we understand that there are some employees with respiratory problems that will be asking for this exception. Same applies for students in the school boards, and this has raised many questions. For example, when the decree was passed on April the 8th, and it was passed without many days in advance, many of these employees expecting to use the exception for health reasons did not have any medical certificate to enable them to request. So there were announcements by the governments that one person should be heard or should be considered as saying the truth, at least for up and until the date or time at which she can seek and obtain medical confirmation. So there were some queries about this exception, and the overall result of that today is that we found out that there's not much otherwise real health reasons in the circumstances. So this is the story about that. Now, it's obvious, Nelly, and it's important to recognize that it's always the employer's responsibility to ensure that the employee wear the mask. So the first responsibility is to supply the mask. And we understand that the government waited until the decree was passed until all these masks could be available. So it's the first responsibility of the employer to ensure that there are sufficient masks available. And the other is that it's the responsibility of the employer to ensure that a mask has to be worn. And this is important because it could have consequences on the responsibility of the employer in case an employee contracts COVID-19. And we know that under certain circumstances, it could be very serious and could be a very serious threat to the employee's wealth and health. So it could, cause employers' responsibility if one employee that did not respect the obligation was not required to do so. Now, as to the reopening plan, it was already announced that on June 25th, there were easing of requirements on wearing masks and distancing on oneself from private gatherings for people vaccinated with 2 doses. And this has already been, is already in the process of being enacted. And the government also announced that in the end of August or later, there would again be more reduction in the requirements for masks in the future. And I think this is going to be good because I think the population is getting tired and the employees are getting tired of working with masks, and we see that it's becoming more and more difficult to enforce these obligations. So I hope, Nelly, we had an occasion to go over that question. Maybe you have others on these topics.
The vaccination campaign for the general public is underway in Quebec. Many employers are planning for a gradual return to work, and one of the key issues is vaccinations in the workplace. Can you tell me, what does the Public Health Act say regarding compulsory vaccinations?
The Public Health Act states that the government can order mandatory vaccination for the entire population or part of a population in cases of contagious diseases. What we've seen in Quebec so far is the government hasn't gone there, hasn't ordered mandatory or compulsory vaccination for the population. I believe that the simple fact that we've been, dealing with this pandemic for almost 15 to 16 months now, is an incentive to have people go on a voluntary basis. So I don't believe that the government will have to go there, but as we stand now, it's really on a voluntary basis that people are getting vaccinated.
Speaking of vaccinations, we heard and read in the news that some employers are giving bonus or incentives payments to their employees to get the vaccination. What is your point of view on that approach?
So Nelly, I've read the articles as well where we see that some employers are giving bonuses or incentive payments to their employees to get vaccinated. So, is this a good practice? Our recommendation is not to provide an incentive payment or a bonus to employees who are getting vaccinated. Obviously, depending on the size of the organization, the industry, the answer may vary, but generally speaking, it's not something we recommend. The reason for that is, incentive payment or bonus for having an employee get vaccinated may result in, some employees being treated differently if they refuse to get vaccinated on the basis of a protected human rights ground. For example, someone who's pregnant, on a religion basis, or for disability reasons. So, and that obviously can give rise to human right related claims. So for those reasons, we don't recommend employers to have, an incentive payment for vaccination. It can also cause stigmatization in the workplace. For employers who are governed by a collective agreement, obviously, they need to have discussion with the union to see how and if, an incentive payment is possible. So generally speaking, we don't recommend it. An alternative, there you go, that we do tell our clients is, there's no problem in encouraging vaccination and providing, educational information to their employees. Obviously, we cautious them to provide accurate and scientific information that is available to the public, and not go and not make statements or draw conclusions on elements on which they don't have the required qualification. So we encourage them to provide information to employees to encourage vaccination, but not necessarily through incentive or bonus payments.
Can employers require that employees be vaccinated before returning to work?
So, Wendy, that's a really good question. A lot of our clients have been coming and saying, can we impose vaccination? And if so, how does that work? So in Quebec, there obviously the right to, physical integrity, and refusing vaccination is the principle. Okay, so that's the basis, that's the general rule. However, an employer can require that certain positions be vaccinated if they're able to demonstrate that it's a bona fide occupational requirement as per the Quebec Charter. So that's the exception. If they can prove that it's justified for the position, then they can require someone to be vaccinated. However, it's quite a high threshold. Someone has to demonstrate that there's a rational connection with the position, that it's a legitimate work-related purpose, and there's no other means to achieve that. So to protect the public or to protect, the clientele. So it's quite a high threshold. Not a lot of positions will fulfill that high requirement. So in most cases, employers won't be able to impose mandatory vaccination.
Knowing this information now, what position can an employer take when one of its employees refuses to take the vaccination?
This is a very good question, Nelly. What do we do if we have an employee that's refusing to get vaccinated? The first element that an employer needs to look at is what's the motive or the reason behind the refusal. Okay, is the refusal to get vaccinated, simply personal? So, unwillingness for personal reasons, or is it because they're invoking protected ground? For example, I was telling you guys earlier, for religious reasons, someone who's pregnant, or a disability. Because depending on why the person is refusing to get vaccinated, then I guess the position the employer will take is going to vary. If the refusal to get vaccinated is based on a protected ground or protected by the charter, what will happen in this case is it will trigger for the employer the obligation to accommodate the employee. This may, result in modifying, for example, the schedule, the type of task that the employee is doing, or maybe changing rotation, or those are the types of modification or changes that can sometimes be required by an employer. Obviously, the obligation to accommodate has a limit, and the limit is undue hardship. So if there's an accommodation that can be made, which doesn't cause undue hardship, then the employer must make some changes to the workplace to accommodate. However, if, for example, the refusal is for personal reason, then the obligation of the employer varies, and it's not the same thing. As I mentioned earlier, the right to refuse to get vaccinated is well recognized in Quebec in the Civil Code and the Charter of Human Rights and Freedoms. That being said, what can an employer do if someone refuses to get vaccinated on a purely personal reason? There's not a whole lot of case law on this subject, but we were able to find one decision that dates back in 2008 that relates to the health sector in a unionized context. So the facts are quite simple. This was a case of an influenza outbreak that occurred in a long-term facility home. The plaintiff, which was a nurse, had been in contact with a patient that was infected by influenza, and the plaintiff was not vaccinated. She had refused a couple of months earlier for personal reasons. there was a protocol put into place by the employer that in a similar case like this one, if an employee was infected or put into contact with a patient that was infected, they were removed from the workplace for a couple of days, which was like the duration of the incubation period of the virus. The union filed a complaint saying that this was not reasonable because it was without pay. The arbitrator in this decision reiterated the principle that a vaccination is an intrusion into the person, and anyone has the right to refuse to get vaccinated. However, he does continue by saying that in this particular case, there was a real risk for the clientele in having unvaccinated caregivers could have some consequences. So in this case, because it was strictly personal, the arbitrator concluded that the protocol put into place by the employer to say, look, if someone does not want to get vaccinated, it's okay, it's their right. But given the fact that the clientele is at risk, the employer is justified to remove the employee from the workplace without pay for the duration of the incubation period. So the takeaway from this decision is that should an employee refuse to get vaccinated on personal reasons or for personal reasons, then in certain situations, the employer is entitled to apply administrative measures that can go as much as someone being removed from the workplace without pay for a certain period of time. Again, this decision was based on someone who refused for personal reasons, but the decision may very well vary if the motive for refusal to get vaccinated was related to a protected ground as per the Quebec Charter.
What should employers do if employees refuse to return to the office, claiming that it's unsafe?
Wendy, your question is quite relevant. With the vaccination campaign well underway, we're seeing people that are going to be most likely in the fall asked to return to work in some capacity. And one of the questions that comes is, what happens if someone refuses to come to work and claims that it's unsafe because of COVID? Everybody has in Quebec the right to, a safe and healthy working environment. But for the employee to raise or to refuse to go to work, that person needs to have reasonable ground or a reasonable reason to refuse to perform his work. There needs to be some kind of danger. It's not enough to say, they have apprehension or they have fear related to COVID-19, especially if the employer puts all, or follows all of the public health requirements. I believe that there's going to be a lot of apprehension. We've seen it. Some employees have already raised, some concern, but concerns are not reasonable ground to say there's an actual danger of not going back to work. That's for most people, because obviously if an employee has a medical condition that could justify them raising that there is a danger to the workplace, obviously that would need to be evaluated on a case-by-case basis. If we do, if an employee does believe that either the employer is not, complying with the health requirements or believes that there is a real danger to his health, they can file, a formal report to the employer, and then the employer then has the obligation to take the necessary measure to investigate and really address whether or not there is a danger to the health of the employee. if the employee and the employer don't agree as to whether or not, there is a real danger, the employee can file a complaint before the SNES, which will then, appoint an inspector to come and determine whether or not the workplace is safe. And obviously the employer has the duty to protect the health and safety of their workers. So if there's something that needs to be adjusted, that can be or will be addressed by the SNES. But like I said, I believe that when we're talking about the COVID-19 pandemic, a lot of it will just be apprehension from employees, and it's going to be, more a question of communicating and addressing concerns with employees, and providing a clear plan as to what are the measures that are being put into place and how gradually the return to work will be done. But there is, obviously a legal mechanism in place for situations where there is, reasonable ground that there is a danger to the work. There is obviously, procedure in place that employees can use to make sure that they are working in a safe environment.
So we know that employees have been working from home for well over a year now. Some of our clients are wondering, what are the best practices that have emerged?
Yes, Wendy. Well, this is a very interesting aspect, because it's likely that the most important practices in human resources management that will carry over after the end of the pandemic is that aspect. The good news is that most of the statistics that were issued show that remote work has shown increase in performance and efficiency of employees, where employers are able to manage performance by deliverables instead of mere hours of work. And so this is good news, and it may be a practice that will increase productivity in Quebec in general, especially in the service industry. Now, but there's a bad news associated with the end of the pandemic, because we know a lot of employers today that really are worried about how they will get their employees back to work. So it's going to be an interesting challenge in the future in human resources. Now, good practices, and I won't go over all of them in details, but the most important practices is developing new management approaches for the performance assessment. So employers are now obliged to go deeper and get better in performance assessment, because it's the only way to control work. And we talk about day-to-day work and also weekly and monthly performance, which will be a challenge. Now, the other aspect and the good practices that develop regard good communications in general. How the employers, supervisors, and managers will take care of the individuals that may be at problems or living problems individually, and how the manager can take more time individually with these persons to ensure that we're back to normal processes. And also good practices have been developed on using all IT tools available to develop employee engagement and creativity. So we developed employers develop all sorts of ways of making parties in video conference, and in also making interesting work meetings with employees with interesting questions and projects. So these are good practices. Now we can always say that it's going to be crucial for enterprises to adopt work from home policies in the near future, unless they want all their employees to to work. You know, the legal issues on these matters are quite simple. We're going to see it later in a few questions, but in Quebec, first of all, there has been rulings by the tribunals that the fact that an employer obliges his employee to work out of home is a violation of the employee's right to privacy. And so that has consequences, and we're going to see it in a few minutes. There is also a rule that emanates from a contract of employment. The employer is allowed, as a general rule, to require that the employee is present on the work premises to perform his work. So it's the other rule. Now, there are also rules for health and safety that are important in such a matter. It's already been ruled by the authorities, by the tribunals, that if an employee is required to work out of home, that home is the place of work, which includes that the presumption of a working accident applies if the employee injured himself while working out of home. So it will be important in our policies to ensure that the employer will determine with the employee what is the exact place of work. In my point of view, it shouldn't include the employee's kitchen and other places like that. And also, it will be important that the employers ensure that the ergonomy is respected. In other words, if we do it permanently, it would be useful that the employer delegates an ergonomist to visit the employee's home in order to ensure that his workplace or workspace is in conformity with the laws. So these are the good practices we can talk about, but it's a good question already. When before the COVID-19 started, many employers were experiencing shortage of manpower, and one of the tools that were recommended in order to be better in retaining and attracting new employees was to offer work out of home. So it's now that the employers have been forced to implement these policies, I think it will be an interesting tool in the future.
We know that some employees really enjoy working from home, remote work. Can employees validly request to keep on working from home after the work from home obligation is lifted? And how can employers handle such a request?
At the end of the pandemic, when the government's decree recommending working out of home will end, then we're back to the same rules. And the normal principle is that the employer is allowed to require from all his employees to work in the workplace. So they need to work out of the workplace, and an employer can require all his employees to do that. Now, an employer can do that for every day of the work week and every hours, and the employer can always also do this partly for some days in the week or some hours during the day, and there's no doubt that this can be imposed unless there's something else in the contract of employment.
Can working from home be imposed by an employer? And if so, what are the risks?
It's been already ruled that an employer is not allowed to impose on his employee to work out of his home. It's been decided that it was in violation of the employee's right to privacy. And if it can go as far as the employee obtaining for a court an order to the employer, which will impose that the employee's freedom be respected.
That concludes this episode of Canadian Lawyer TV. Thank you to Langlois and their partners in Montreal, André Sasseville and Annie Bourgeois, along with Nelly Admo and Wendy Glaser. And thank you for watching Canadian Lawyer TV.